Hi everyone, this is Don Koppy again with Laura Jo Lieffers, and we're going to cover the second part of general conditions. Again, an AIA program based on the CSI way of doing work along with the AIA A201. Again, talking about general conditions. Don't get it confused with general requirements and all the other generals that the CSI has in their lingo. Of course, is approved for CEUs. A quick step back, just again, we're talking about using the A201 in a standard tri-party relationship agreement. As you see that there's a link caused by the A201, but they are separate agreements. And then again, remember that you should use the particular family of documents. If you're going to use the AIA general conditions, use the AIA forms. Don't go trying to use the DBIA forms or the EJCDC forms or the AJC forms. So we're going to start off with Article 7, changes in the work. What changes? There's no changes in the drawings. Never changes in the work. Owners never change their minds. Project just runs smoothly. What are we talking about here? Laura Jo?
All right, well, a quick refresh. The two red plus signs, if there's a red plus sign on your slide, that is going to be extra important for your exam, so just keep that in mind when you see that. The changes in the work, as we mentioned, there usually is at least one change or so when dealing with construction projects. And we talked briefly about ASIs and CCDs and change orders. These instruments do not change the contract terms. The original provisions remain intact. This is important especially for time, as a significant change can impact time. Therefore, time should always be addressed in a change order. Too many ASIs might trigger a change order or a change in time request as well.
Yeah, just one note too. The interesting thing about construction law is the fact that they're expected to make changes, and a lot of other legal agreements, if somebody makes a change, you can basically throw out the contract. But it's well known that under construction we're going to have changes, and so we do have these mechanisms to cause changes. But on the same part, we have to be very careful as to how we use these changes and making sure that they're properly documented and made part of the construction contract.
And the documentation is you'll see it's going to be of the utmost importance. And the AIA documents will have forms for each of these types of changes. So put it in writing. Use a form if you have the form, especially within the same family of documents that you are utilizing for the project. Okay, so a change order, a written instrument prepared by the architect, signed by the owner, which is very important, and the contractor. So basically agreeing to the change in the work, change in schedule, change in price, and that sort of thing.
Keep in mind, notice that the architect is not required to sign the change order because it's a contract between the owner and the contractor.
A construction change directive, a different type of change document. The CCD, as we'll call it, is used in the absence of a formal agreement on the change in time and the change in money, so the GC can proceed. So we suggest using those sparingly and as a last resort, as when you don't have terms, definite terms to a modification or a change in the agreement, there could be some discord among the parties. So just keep that in mind. Usually this is used when there is not enough time to price out properly a change order. You want the work to proceed, you don't want to delay. But
example of that is if you discover some contaminated soils on the site, you got to keep the project going. You don't know the extent of it, so you say, okay, go ahead and remove it, and we'll pay you on a time and materials basis or something along those lines. obviously you don't want that extending too far along. And once that work is resolved, it's important to get that clarified and put into a change order.
Yes. All right. So there are different methods for the adjusting of the contract sum: unit price, lump sum, fixed or percentage, etc. So again, get it in writing, get it signed, the contractor's signature indicates agreement, and always, pay special attention to making sure that those things are documented or eventually turned into a change order, whatever needs to happen. The contractor does not agree with the method, then the architect will determine the reasonable method of adjustment, including maybe time and materials, rental costs, that sort of thing. This is a very labor intensive and a burden on the GC, so therefore they will usually negotiate a reduced price for a lump sum.
And it's also very labor intensive for the architect to go review it all.
Yes. Again, keep the use of those CCDs limited. For the minor changes in the work, you have an ASI. Again, you have a form in the AIA documents for this. ASIs are for minor changes in the work, such as dimension clarification or correcting a note, but they don't add any cost to the project.
An example of this could be that you change the color of the paint on the wall, or a color of the ceiling tile, or a wall tile along those lines for finish.
And that change is not inconsistent with the original contract documents, and it won't cause a change in cost. So, time, very, very valuable, and also litigated fairly often, delays and that sort of thing. So in the definitions, you're going to find some important terms. For instance, the substantial completion date, the date of commencement of work. These things are going to be contained within the contract language. So look there to see if what the contract time is, how long, what type of period of time are we looking at for the project to become complete. And also a definition of days or calendar days unless they are otherwise defined. So pay particular attention to the definitions in whatever contract that you are working with for your particular construction project. And as always, usually, time is of the essence. And the contractor, by signing, confirms that the contract time is reasonable for him to complete the work. The contractor cannot prematurely commence operations before the effective date of the insurance. Insurance is very important.
Always make sure you get the insurance before they step on the job site.
Yes, and we'll talk about that a little bit later as well. But the contractor's goal should be to achieve substantial completion within the contract time. That should be everyone's goal, working together. So delays, you will come across delays. They're sometimes unavoidable in construction projects. So if the contract time does become delayed, the time can be extended by a change order, and there are different reasons for the delays, which are listed on your slide. And it's very important to have that baseline schedule to compare against. The contract sum will be defined in the agreement. So you will see that it's usually a lump sum, but there are different types, so just pay particular attention to that. A schedule of values must be prepared by the general contractor, and it's usually broken down by labor and materials by each specification section. This might include allowances or alternates, and will usually contain a general condition cost. Again, it's very confusing that we use general conditions so often in different ways, but this is specific to the schedule of values. And the breakdown is usually in the CSI division format. So
it's also very important to get a good detailed breakdown of the schedule of values, because that's what you're going to be using during construction to certify the application for payment.
Right. So you want it as specific as possible. So, if you end up with just 10 line items, and you try to
that's not enough.
You try to certify those payments, it's going to be tough on the architect or the design professional to do that. be great for the GC, I'm sure, but all right, so what we were just talking about, applications for payment. The contractor is going to submit basically a version of the schedule of values that shows the amount of work that's in place in order for the GC to get paid. So the payment for the stored materials need to be addressed. It might require a certified invoice or a bonded warehouse. The subcontractors must be paid. The GC is paid. And things like lien releases, partial lien releases, that sort of thing we don't really address here, but important in contracting for a construction project.
Yeah, the process is usually the pencil copy is what it's called, is submitted, and it's reviewed by the architect and sometimes the construction manager if they're involved on a project, and walk through it and verify that yes, that amount of work is done.
Yeah, so always walk through. I mean,
yep. And then
verify that
they'll
work.
Once that comes to agreement, then an actual inked copy will be included.
And again, the AIA has a form for the application for payment. I suggest using that form. It breaks it down so you can see the progress of the construction project. Certifications for payment. This is where the architect will make a qualified statement, certifying that the work was done, and that happens once the contractor's application for payment is received. And the architect will perform one of the following: issue the certificate for payment to the owner, or notify the contractor and the owner for the reason of withholding certain payments. Again, not to be done. The architect does not need to do an exhaustive review of the site, but it's important to make sure that the work has progressed to the point that's indicated on the certificate for payment, and the quality is in accordance with the contract document. So,
and make sure the liens a release of liens are provided.
Yep. So a certificate for payment is not a representation that the architect has made an exhaustive, continuous on-site inspection or observations, as some call it, or reviewed means and methods. Basically, it's not a representation of things that the architect is not required to do. So the final payment application should not be signed until all the work is completed, including punch list work and closeout documents, that sort of thing.
For the final payment.
For the final payment. Okay, a decision to withhold certification. So that is within the realm of the architect's responsibilities, withholding a certificate for payment in whole or in part, to the extent reasonably necessary to protect the owner's interest. The architect may withhold a certificate for payment, or may nullify the certificate previously issued to protect the owner because of some, they've discovered some defective work that was not remedied, or some type of third-party claim. Off-site storage of materials needs to be in a bonded warehouse. On-site storage needs to be secured. Trailers can be driven away. So since the owner takes title of the stored materials upon payment, it is important that those materials are safe and secure.
Yeah, I was given an example of I had just walked through a project and did a certification of payment. And as I was driving home, I heard on the radio that the apartment complex was on fire.
Oh, no.
So I immediately turned around and drove back.
Oh, no.
And first thing I looked for was these trailers that had this material that was in it. And they were no longer there.
Oh, no.
But it was the contractor who pulled them away because they were too close to the fire.
Oh, okay.
So it's important.
Still scary.
It's important that I had told the contractor I was not approving. It was the dishwashers that were going in, and the dishwasher plumber actually started the fire by doing soldering and his plumbing, and
hope that insurance is in place.
And the contractor was really upset at me for the fact that I didn't approve the storage of the materials on site for the trailers. But there's a perfect example of why you don't do that.
Oh man. Okay, so the architect should not unreasonably withhold certification. So Do not use this as a weapon or an act of vengeance against the contractor. Working together to try to, fix any issues or get anything resolved is probably in the best interest of all parties to efficiently complete the work.
Yeah, regardless of how contentious issues may get out there, if they've done the work and it's per the plans and specs, you need to pay them.
Yep. And that will hopefully keep claims down just overall.
Hopefully.
Okay, progress payments. One of the important things to remember here are the release of the liens are commonly required with each application for payment. This is an assurance that the subcontractors and the suppliers are being paid. So this is a protection for the owner. The owner or the property can still be on the hook for any unpaid balances without those releases of lien being presented by the contractor. So verify that the contractor, along with a certificate of payment, is providing those releases of lien, partial or full, depending on what type of work is being completed.
And I've received phone calls from subcontractors who hadn't been paid for a month or two.
Very frustrating.
I bring that up at the next meeting and the progress payment to make sure that they do get paid.
The contractor can stop work until payment is received if the following has happened. Architect does not issue the certificate or the owner does not pay the contractor. So this is after our cure period, of course. But this is the contractor's only contractual ability to stop the work. This is the only time. Substantial completion is an important date. This means that the building is available for use by the owner for its intended purpose. A certificate of occupancy is often obtained. At this time, the contractor must prepare an initial punch list and the architect then makes an inspection. So this is the first of two times that the architect inspects the work. So when the work is substantially complete, the architect basically prepares the certificate saying that and establishes a date of substantial completion. There's punch list. They fix a time for the contractor to make those, to correct those issues on the punch list.
And a big component of it is that you need to establish what's now the responsibility of the owner and the contractor, especially if you're doing partial substantial completions. Let's say it's a remodel and it's in phases. Okay, but at the point of substantial completion for the AIA document, the owner is now responsible for security, for maintenance, for all the heat utilities, any damage in particular, and for the insurance involved with the project. So it is a major turning point for the owner and the contractor.
It triggers a large change in liability on many fronts. So exactly. It's an important date. The warranties commence on that date of substantial completion, and upon acceptance by the owner and consent of the surety, the owner makes payment of retainage, which sometimes can be up to 10%. Now, the GC's first one-year warranty period is now referred to as the correction period. You should hold back enough retainage to complete the punch list by another contractor. Partial occupancy or use. This might be before the entire building is completed and the owner needs to use the space for furniture or equipment installation, or a portion of the building is needed for sales. So, for an example, an administration portion of a school building, this space might be occupied by the school administration staff while classroom work is still being finalized. So identify conditions to verify who damaged what during the move-in process. Final completion and final payment. Importantly, this is the second time the architect is required to make an inspection. And inspection in your world is different than observation, is that right?
Absolutely.
And also, there is specific language within Article 9.10.1 that should accompany the final application for payment. And also, the consent of surety is a vital component of final payment approval, as well as those final releases of lien. You don't want the owner to have to pay twice for any of the work that has been performed. And many documents are required to be submitted before the final payment is made. Again, the consent of the surety is very important, as the surety is a third party to the contract. If there is work that's not completed or faulty, the surety might not agree to final payment. So then the surety is the entity that issues the payment and performance bond that the GC provides to the owner, which assures the payment and completion of the GC if the GC defaults.
And a major component of it is that acceptance by the contractor of the final payment constitutes any waiver of any further claim for the construction of the project. Any questions? Protection of persons and property. Safety precaution.
The owner and the architect need to check into the contractor's office when they are on site. This is more than just a courtesy because the contractor, as we've talked about before, is responsible for the safety on site. So,
absolutely. If you're going to go visit the site, make sure you check in, make sure you wear your hard hat and your steel-toed shoes.
Follow the rules, essentially.
Exactly.
All right, and again, the safety program should be provided and managed by the general contractor. And the contractor is responsible for that safety program and some of the items listed here, complying with the applicable safety laws, statutes, ordinances, and codes, maintaining safeguards, remedying any damage or loss, that sort of thing. If either party suffers injury or damage because of an act or omission of the other party, written notice to that party is required. Notice should contain information to enable investigation. So written notice is an important thing that you need to keep in mind for many facets of this contract.
Now, this is something that people have asked before. It's like, well, can't the contractor stop the work if they hit hazardous material? And note that the work is not stopped. Just only the areas impacted.
Right. So they may stop the work in that particular area, but not the entire project. And the owner is, of course, responsible for any necessary cleanup costs. In emergencies, the contractor has the duty and responsibility to act. Oh, insurance.
And bond.
Get that insurance. It's important to know about these types of policies, and they'll be covered again, I'm sure.
In a later session.
First is the contractor's liability insurance. This is something that the general contractor pays for. It's a general liability policy. So they buy it and maintain the insurance throughout the entire project. Owner's liability. Owner has basically a separate policy for liability insurance that they pay for. Property insurance. This may be a little confusing, but by virtue of the name, but it is generally a policy that covers the work in place and paid for. And if you do have, say, a fire start during construction that burns down half of the completed building that's been paid for, this type of policy will cover that peril. The loss of use insurance. The owner is delayed from occupying the building and collecting rent, but still has a mortgage to pay for. This type of insurance will come in handy for that. Good examples are schools, stadiums, apartments with pre-leased facilities, with loss of revenue, where the owner will incur added costs due to the delay in occupancy. All right, performance bond and payment bond, also very, very important items to the contract. The owner has the right to require the contractor to furnish these bonds, covering faithful performance and payment. So basically, it's a way for the owner to make sure that the work is done.
And this is usually required by the lenders.
Yes. The performance bond ensures that the work will be completed, and the payment bond ensures that the contractor will pay for all of the labor and materials, essentially making sure their subcontractors get paid as well. Uncovering and correction of work. The architect may request portions of the work to remain uncovered for further examination. And we talked about this a little bit in the last session. The architect may request uncovering a replacement at the contractor's expense if some type of work is found to be defective where they uncover.
And if they uncover it and they find out the work's not defective,
right.
then the owner has to pay for it.
Right. So just use with caution. Use this with caution. All right. So note that the contractor is required to correct and complete the work before and after substantial completion. The requirements of the contract documents are not waived by acceptance and occupancy of the work. This is why it's also in the contractor's best interest to request a change order for variances in the work at the end of the project, where the owner has accepted non-conforming work, which the owner has every right to do. So just make sure it gets in writing. So if 10 years down the road, there's something that's different than the original contract documents, make sure it's documented. Again, non-conforming work should be adjusted and documented by change order. Got a little ahead of myself there. So the owner may accept non-conforming work instead of requiring removal and correction. So the contract sum will be adjusted appropriately. In miscellaneous provisions, governing law, that will be provided by contract. It will state which jurisdiction will apply. Successors and assigns, the owner and the contractor bind themselves, basically any entity related to them, to the agreements and the obligations contained within the contract document. Written notice. Just remember, if you think of doing anything really during the course of construction, make sure it's in writing. And if you want to notify someone, do it in writing. The rights and remedies, the duties and obligations imposed by the contract documents are in addition to those available by law. Tests and inspections are required by the contract documents and required by usually the building code. So the contractor shall make arrangements with those testing entities and will bear the cost of those tests and also bear the cost to remedy any defective work that's found for testing. The owner will bear costs for test inspections or approvals required after bids are received, and bear any costs for test inspections or approvals where the law prohibits the owner from delegating that cost to the contractor. If additional testing or inspections are required, then the architect will instruct the contractor to perform, and the owner will bear the cost if the work conforms to the CDs, and the contractor will bear the cost if the work does not conform. So that's kind of a common thread throughout the A201, the bearing of the cost on particular parties. And of course, interest payments are due, unpaid payments bear interest. Time limits on claims. The owner and the contractor commence claims and causes of action against the other according to the agreement. And in Florida here, 10 years is the statute it proposed. So there are more specific statute of limitations that are even more narrow than that within Florida statutes. So it's important to know those time frames and just be cognizant of them. The termination of the contract. So the contract may be terminated if the work is stopped for 30 consecutive days through no fault of the contractor. This could be an act of the government that requires the work to be stopped, or if the owner fails to furnish evidence of its finances to fulfill obligations, or the owner has not paid the contractor. So the contractor may terminate if the work is suspended for an extensive period of time. Again, there's a variety of reasons this could happen, but the written notice time frames are important to remember. So for instance, the contractor may, upon 7 days written notice, terminate the contract with the owner and recover payment for work executed. Termination by the owner for cause. The owner may terminate the contractor for cause if the contractor refuses or fails to supply workers and materials, or if he or she fails to make payments to their subcontractors, disregards the codes, etc., breaches the provision of the agreement. And we talked about the initial decision maker in the last session, but that's someone that's defined within the A201. If this initial decision maker certifies cause exists, the owner may terminate the contract.
Important note is that there's certain notices and cure periods that occur, and there's definite procedures to follow.
Absolutely.
If a construction contract is going to be terminated, it's a very, very serious thing.
It's very serious and should be a slow process. It shouldn't be fly by the seat of your pants type action. Again, so when the owner terminates for a cause, the contractor is not entitled to any further payment. However, if the unpaid balance exists, the excess shall be paid to the contractor.
And if termination is being pursued, surety needs to be notified.
Yeah, absolutely. So the owner might suspend the project for convenience. An example of this might be that the lender defaulted on the loan, or the loan was taken over by another bank and the terms changed. The market changes the building and requires extensive design changes, or perhaps a hurricane strikes and floods the building, the local hotels are out of service, etc.
The casino that you're building is not going to be profitable.
Right.
So that has happened to be there.
The owner may terminate the contract for convenience and without cause. And if so, the contractor shall cease work, take action to preserve the work, which is important, and terminate all the subcontracts and purchase orders. Now, the contractor is, of course, entitled for payment of the work executed, overhead and profit on the work not executed. Interesting.
Yep. So if they're going to terminate just because they feel like terminating, the contractor does get his overhead and profit.
So essentially, they try to make the contractor whole as if he was to actually complete. Yep.
Claims.
These never happen, right? All right. So the timing of a claim submission is very important, and a claim may be rejected if not submitted timely. This goes for informal claims and also formal, more litigation type claims. And the timeliness is always of the utmost importance. So when you demand or assert seeking payment of money from another party, then must be initiated by written notice to the other party and the initial decision maker and architect within 21 days after the occurrence of the event giving rise to the claim and the condition giving rise to the claim first recognized. So while the claim is pending resolution, the contractor should proceed with the work. That's important. And the owner should continue to make payments, but the dispute resolution will be kind of going on in the background while the work continues. If the contractor wishes to make a claim for increase in the contract sum, written notice is required prior to executing that work. If the contractor wishes to make a claim for increase in the contract time, again, the written notice is required with a cost estimate and probable effective delay on the progress. If weather conditions are the basis of a claim for additional time, there are certain things that you need to ensure before you make that claim. The local weather data should be used for comparisons of rain delays. Rain days should be built into the project from the very beginning. So that should not be a common excuse during the project. It should have been anticipated. Claims continued. So it's always good to resolve claims as quickly as possible. Note that liquidated damages may be used to take care of owners' claims for loss of use or income. So always check those contractual provisions related to any liquidated damages clauses.
One claim can start to overlap onto another claim if you let them drag out, so it's best to resolve them as quickly as possible.
Yep. Again, whoever is defined as the initial decision maker, that will be the first line of the resolution process. So the claims are referred to the initial decision maker, and then he or she reviews that claim and investigates.
And typically it's the architect, the initial decision maker.
And often settlements are negotiated and that sort of thing. Sometimes lawyers do get called in to resolve the dispute, and then everyone loses because the cost of the settlement often exceeds the value of the claim. So if you can resolve it without bringing in additional advocates, that's always good. Sometimes it's necessary to do so, but if you can go ahead and reach a compromise, maybe splitting the cost is often an equitable way to solve the dispute.
And keep in mind that all claims go through the initial decision maker first.
Yep. Mediation is a good way, a good first step in resolving the dispute. So this may involve a third-party mediator with extensive dispute resolution and construction experience. We work with some great mediators that have years and years of construction law mediation experience. Arbitration is another way, other than filing a lawsuit in state court. Arbitration is an alternative dispute resolution mechanism. Prior to a court case with a trial and a jury, the parties may enter into the arbitration, maybe not non-binding or binding, depending on the contract language. Some say it's less expensive than a court and jury, typical litigation, but that's not always the case. So just keep, prior to filing suit or issuing a demand for arbitration, mediation is a great way to try to resolve these claims in an economic fashion. So once you get into arbitration or into state court, the costs go way, way up.
Just a final plug for Laura Jo.
If you run into a problem, give me a call.
Thank you very much. I appreciate your time in these last two sessions. And we'll see everybody